Are you ready to transform your normal e-commerce business into one that experiences exponential growth year after year using online advertising? If so, this show is for you. Me and my guests will show you how you too can grow your e-commerce business to 7 or even 8 figures so you can go on more luxurious vacations, spoil yourself and your family, say yes to more opportunities, and become financially free so you never have to worry about money again. Welcome to the E-commerce Performance Marketing Show.
Hey, how's it going, guys? Josh Marsden, your host of the E-com Performance Marketing Show, and I have an incredible guest for you today. I have Rich Goldstein here. Rich is a patent attorney that really caters to e-com companies. He helps e-com business owners protect their patents and their IPs, and basically just making sure that nobody else can step into your industry and try to rip you off, essentially. So it's a very, very important episode for you today that you're definitely going to want to pay attention to throughout the entire episode. He's also the host of the Innovations and Breakthroughs podcast and the author of the ABA Consumer Guide to Obtaining a Patent. I'm really excited to interview him for you guys. He's going to deliver some tremendous value. So Rich, welcome to the E-com Performance Marketing Show.
Thanks so much, Josh.
Was there anything there that I missed?
There's always something, right? But it doesn't matter. We just talk and see whatever we need to talk about to serve your audience.
Awesome. I appreciate it. Well, if you could maybe just tell your backstory a little bit, just so this way the audience can get to know you a little bit, just to kick things off, that'd be awesome.
Okay. Sure. I mean, how far back do you want me to go?
However far back you want to go. Like the most unique story you've ever told about yourself.
Okay. So, well, I mean, I started out on the path toward being an engineer. So I went to a pre-engineering high school. I went to college for electrical engineering. And at the same time that I went to, that I started college, I also started a business selling beauty supplies, going to salons and selling all of the different supplies that they use, like the tools that they use, the chemicals, etc. And so I'm 17 years old, going basically door to door or salon to salon, just showing up and selling. And so even though I was studying electrical engineering, I had an interest in business. And I also realized that the reality of being an engineer meant that I'd be working on the same project day in and day out for years at a time. And so it seemed like that wasn't the right path for me. So I thought about changing my major to business because I liked business, because I was running a business. Then I heard about patent law, which is a field where you need to be a lawyer and also an engineer so that you could understand the technology. So I finished electrical engineering and I went to law school. And now I get to work on something different every day.
Yeah, that's awesome. That's cool. It's really cool that, back, when you were going to college, that you saw the opportunity to get into patent law because of the fact that you're already in the engineering, discipline within college. Give me, if you could maybe give the audience maybe a few cases, just a few examples of how important that patent law is to their businesses and what it can really do for them. That'd be great.
Got it. Yeah, well, I mean, there's a few different levels to why it's important to understand IP, first of all. I'll submit that IP is probably the most critical thing to e-commerce businesses that most e-commerce business owners know the least about. So it's a really high leverage point, is understanding IP. Because usually it's the weakness. You, as an owner of an IP business, you might know a little bit about how the listings work and how to optimize listings, a little bit about PPC, and of course you hire experts to help you really maximize that. And a little bit about fulfillment and shipping, like what type of box products need to go. And I don't know. A little bit about everything related to e-commerce. But most e-commerce business owners know practically nothing about IP. And when it comes down to it, even worse is they often have misconceptions. So worse than knowing nothing is they think they know something, but it's actually steering them in the wrong direction.
Yeah, what are some of those misconceptions?
Well, one of the misconceptions is that they see a patent number on a product and they say, oh, that's it. That product is patented. So there's a misconception that a product itself gets patented and like, oh, I guess I can't copy that product because it's patented. The product isn't patented. Some aspect of that product is patented. Some combination of features in that product is patented. And so just because you see a patent number doesn't mean you can't make any products like that. That means that there's something specific there that they've done that's new that you need to stay away from. So with a little bit of analysis, you might be able to find out, well, what is the prohibited territory there? And then you can still make a product that competes. So, and from that same misconception is, people will then look up a patent number and they'll find the patent and they'll find the owner of the patent and they'll say, well, I guess I need to purchase this patent because they have the patent on it. Whereas, and I've seen people spend, $50,000, $100,000 buying a patent that I look at and I say, you didn't need to buy this patent. There was no reason you couldn't just go into this business and do what you were doing without this patent. So there is a lot of misunderstanding there about it.
Absolutely. I could definitely see that. Because, I didn't know that. And if I didn't know that, and I've been obviously in e-commerce for 7+ years, serving e-com companies with my agency primarily, I'm sure that a lot of people watching this don't know that either.
And there's another misconception that's very common is people believe that if you get your own patent, then that means you can't be infringing anyone else's patent. So sometimes people will say, I want to get a patent so I can make sure that no one can come sue me. And it just doesn't work that way.
Yeah.
It's like you can have a patent and still be infringing other people's patents. And most people don't realize that. I'll explain the way it works. I see the confusion in your face in this moment. So let me explain.
It's all questions right now.
Right, exactly. All questions. So it's kind of like, it seems logical, right? That if you're able to get a patent, that means you're different enough from other things that you can get your patent, and therefore you must be different enough that you're not infringing. It doesn't work that way. And let me just give you a simple, kind of dumb illustration so you can understand why. So imagine you invented the chair with 4 legs and a seat. And so you're able to get a patent on the chair with 4 legs and a seat. I come along and I improve upon your chair. And I say, you know what, like, this is killing my back. I need to do something. So I say, what if we added something in the back edge of it, sticking upwards, that I could lean against when I'm sitting on this chair? So now I've improved upon your chair. So according to the patent office, I can get a patent on that improvement of the chair with 4 legs, a seat, and a seat back. But in order for me to make my chair, I need to make the 4 legs and a seat, which is your patent. So I can get a patent on my improvement, but I still have to copy the core combination of what you've patented in order to manufacture my chair. So I would need to get a license from you if I wanted to make my chair.
Got it. Okay. So how does that work? What's that process look like?
The process of licensing?
Yeah. In that example, you can just continue with that example.
Yeah, in that example, I would actually need to contact you and say, hey, I've improved upon your chair and I have a patent for my improvement, and I would like the rights to make the basic chair that you still have an in-force patent for, so I'll pay you a royalty. Or I might say, hey, you might want to add this to your chair as well. How about we do a cross license where I have the right to use your basic chair and you have the right to use my improvement. So so there's different ways to work that out.
Are people, in your experience, are people pretty receptive to those types of deals, or how can you navigate those conversations and get to the end goal that you have in mind as successfully and smoothly as possible?
Yeah, I think any negotiation, it's all about a value and finding where the value match is. So clearly, if there is something that they want in terms of for their own business, if you can ask enough questions to discover that, then it's easier to make a deal, to negotiate something. But I would say generally, patent owners are open to that. The notion of making money for doing nothing, who doesn't want that? So, I mean, I know many people that make more money licensing their products than they do from actually the products they sell.
Yeah. Yeah, I can imagine. Okay. Yeah, I mean, it's just like any other, like you said, negotiation. I mean, you just want to create a win-win. You want to approach it with, that type of mindset where it's not just about your goals and what you want to accomplish. It's about how can I create a win-win here so this way I can accomplish my goals, but they can also have a benefit out of this as well.
Exactly. And I think ultimately, if it's not a win-win, it's going to fall apart anyway. If you manage to put one over on someone and you have a deal that's really strongly in your favor, it's going to fall apart at some point.
Absolutely. I mean, that's life, karma, and unless you have business ethics, it can come back and, bite you in the butt. So yeah, absolutely.
Yeah, totally. And this is all starting from that concept though, that misconception that people believe that you can get a patent to insulate you from infringing any other patents. And that's just not true. So, so the two different concerns. So that's just another common misconception there.
Yeah, no, I appreciate you elaborating on that. That's really helpful. Is there any other misconceptions that come to mind that we can really kind of digress basically and unpack for the audience this way they can learn how to really approach this aspect of business that you're an expert in smoothly and effectively?
Yeah, well, I mean, first of all, I'll roll quickly through a misconception and then I'll move towards a pitfall. Okay. So a common misconception just goes back 100 years or so, is that you can protect your idea by writing it down and mailing it to yourself and then keeping the sealed envelope. They call it a poor man's patent or a postal patent, and it just doesn't work. So it used to be a more complicated explanation of why it doesn't work. Now it's real simple. We're in a first to file system as of the past few years. So even though you've got this proof that you invented it first, it doesn't matter. It's who gets to the patent office first. So that's a common misconception. Mailing it to yourself doesn't make a difference. And then now just moving into a pitfall. Common pitfall is that people think I'll patent it later. So they say, I don't know if this product's going to be successful. Patents cost a good amount of money. Why don't I just put the product on the market, and if it does well, then I'll get a patent? The problem is that under US patent law, when you put the product on the market, when you make it public, if you haven't applied for a patent within 1 year after that, then it's game over. So most people don't know about that 1 year rule. And so a lot of times people will come to me a couple of years in and they'll say, I've got this product. It's selling really well. People are about to start knocking us off, or people are knocking us off. We need to patent this. And I have to give them the unhappy news that it's too late.
Yeah.
And by the way, it's even worse outside of the US. In most countries in the world, if you haven't applied for a patent before it's public, it's immediately too late. There is no 1 year grace period.
Wow. That's super important. E-commerce business owners that are watching this, that's a very, very, very important tip that Rich just gave you, that if you have a new product or you're building one, make sure to get it patented before you actually start selling the product, or if you do start selling the product, make it urgent and contact Rich. Get that patent done as quickly as possible, because like Rich just said, you have 12 months, and then after that, your asset that you created is not protected.
Yep, absolutely.
Yeah. And what happens? What's the landslide there? What if an e-com business owner gets, procrastinates and just puts it off, doesn't do it, 12 plus months pass? What's the worst case scenario here? And I almost want to scare the audience a little bit, just because I want them to see how urgent this is.
Okay, let me give you the non the ordinary, which isn't quite the worst case scenario first, which is that the situation is you haven't patented it. Now anyone can make the product. You have no ability to stop other people from making it. And so then it's just a free-for-all. The worst case scenario, which I didn't even know existed until recently, is that a competitor files a patent application, and they get the patent, and then they're able to stop you. So
oh, wow.
It doesn't happen very often. Like under ordinary circumstances, let's say if you invent a product and you put it out there, and then someone sees it, they apply for a patent, they might be able to get the patent kind of fraudulently, and eventually you can have that patent challenge and you could have the patent taken away. But I've seen other scenarios where it's a white labeled product, and so the person who's doing really well selling the product online is they didn't apply for the patent. They didn't work with the manufacturer, the person who actually designed it, to see what the patent status was. And then they discovered down the road that the manufacturer gave the rights to someone else to get the patent for the patent. And so then that person is able to stop us from making it. And I've seen that, a few times recently, where people are saying, well, it's just a white label patent. What does it matter? But there are scenarios where someone else might have the rights, gain the rights, and be able to stop you. It can get pretty ugly.
Yeah, I mean, just the sound of it just makes me shake my head, as you can see, just because I empathize for anybody that's been through that has worked hard to get their business going, and then all of a sudden they get contacted, hey, you can't sell that product, because they didn't look out for themselves, they didn't take the steps necessary.
Exactly. Yeah. And if you're selling on Amazon, Amazon is not the most reasonable about dealing with these situations. And Amazon doesn't care if you're losing your livelihood suddenly, or if you've basically dotted the I's and crossed the T's on everything else, and you've been a good seller with great reviews, and if they see reason because someone submits a patent that plausibly you're infringing, they'll shut you down.
Yeah, you don't want to go up against Amazon, that's for sure.
And you don't want to rely on Amazon to undo the mess either.
That's true. That's true. So, so you've worked with Amazon sellers and e-com business owners that have their own brands.
Yeah.
Right. So, between those two types of, entrepreneurs, when it comes to, patent law and trademarking and things like that, like what should those two types of entrepreneurs, how should they approach, their businesses, and what's the difference between I'm selling on Amazon versus I'm building my own brand, I'm selling through my own brand?
Okay. Well, first of all, you're selling on Amazon, presumably you're building a brand of some kind. It might not be the product itself. It could be the store that you've created for selling on Amazon. But I would say front and center is always protect your brands. Always do trademarks to protect your brands where possible. Trademarks are relatively inexpensive. I say relatively compared to patents. I mean, think when it comes to patents, you should be more judicious in determining, well, should I patent this or not? But with trademarks, just always do trademarks because, as I said, relatively inexpensive, but you having the trademark can be extremely valuable in a variety of situations. And I think a lot of times when people starting a business and they think about trademarks, they, in their mind, say, well, yeah, I've heard about trademark problems. It could be like $100,000 situation. Let me just not deal with that as long as I possibly can. But the truth is that registering a trademark is a couple $1,000 maybe, and that prevents you from having that $100,000 problem later. If you don't file and someone else files, if you don't file and you're selling your product online, and then someone else files for the trademark, technically you can get that trademark taken away if you were selling before them. You have some rights, but that's a much more expensive proposition than you just filing first. It just becomes
lawyer
a big
versus lawyer,
mess
definitely.
if someone else files before you. So I would say for, e-commerce brands, for Amazon sellers, just do the trademarks. Take care of the trademarks every single time. When it comes to patents, it's a little bit different because patents are expensive and it doesn't always make sense to do a patent.
Yeah, if you could backtrack maybe a little bit, because I don't think we've covered this in the episode. What's the difference between like a trademark and a patent?
Okay, so when you're thinking of branding, that's what trademarks are for. So basically, the name of the product, the logo that you use to along with the product, even a slogan that you use to sell the product, those are all trademarks. So basically, trademarks are about branding. Things about the product itself are typically patents, if they're anything. So things that are different about the product, about the way the product functions, about the physical appearance of the product, those could be patented. So just in reverse order then, if you're talking about just the shape of a product, a unique shape for a product, that's a design patent. And if you're talking about how the product functions, you've got like a new structure that makes it function differently or function better, it's improved the product, that's going to be what's called a utility patent. And design patents are usually on the inexpensive side, not that expensive. Utility patents, much more expensive. Utility patents are all about words and descriptions and like describing the different aspects of the product. And so they're more expensive to do, but also it leads to an important point about Amazon, which is that, traditionally people would say utility patents are better because it protects the concept. It protects it conceptually, where design patents are just about an appearance. And so if you change the appearance, it's not going to infringe. Someone makes it look different, they're not going to infringe your patent. But on Amazon, it's flipped, because on Amazon, if you think about it, someone's copying your product. You want to sick Amazon on them. You want to make an IP complaint to Amazon and say, shut their listing down. So now imagine you've got a utility patent. You send it into Amazon. It's being reviewed by someone for $6 an hour in Bangladesh or whatever. They are not going to understand your utility patent. They're going to see a lot of words and say, okay, well, the patent seems to be talking about 4 legs and a seat, and it says something about the seat from the rear edge of. They're not going to be sure how to interpret it. But when it comes to a design patent, it's all about pictures. So they're going to look at the competing listing. They're going to look at your pictures from your design application, and they're going to say, looks the same, shut them down. So on Amazon, design patents have become a really powerful tool. If you have a design patent and someone makes a product that looks like yours, you'll be able to shut them down. And sometimes unfairly, by the way, because sometimes it looks similar, but then again, they all look similar. It's like, imagine a microwave oven, and like you got a patent on your design for a microwave oven, and then someone else has a microwave oven, and they look at it and they say, oh yeah, it looks similar. It's got a curved handle on the door. It's got a keypad. It's like, it looks similar. So shut them down. But in truth, the infringement of design patents is always subject to what came before. And so clearly microwave ovens have had like a door with a curved handle and a keypad for a long time. You're probably getting your design patent because of some other intricacies of it, but Amazon doesn't realize this. So they'll shut down someone unfairly, which can be a crappy situation if you're the one being shut down. But the lesson is, if Amazon is deferring to IP owners, if they're deferring to people that hold the design patent, it pays for you to be the one holding the design patent.
Yeah, absolutely. Absolutely. Yeah, I hear you. So, if you could maybe just share some, maybe even success stories of how e-com business owners you've worked with have protected themselves, whether it's a trademark or patents, and then they've had to use, that trademark or that patent to be able to protect, their company's assets. Do you have some examples you could kind of go over? And then you also, as you're kind of going over these stories and these examples, can you also share with the audience what the outcome was of those scenarios as well?
Yeah, I mean, it's hard to go into specific scenarios, but in general, I mean, I have seen people who have a design patent, for example, that they applied for the patent, their listings kind of grew in popularity. People were buying lots of their products while the patent was pending, while we were waiting for the design patent. Then, after some time, it typically takes about a year to get the patent, right? So people are knocking them off left and right. And then the patent issues. Now we have the patent and we do an IP complaint and shut down dozens of listings in a single day. So just imagine being able to shut down, dozens of listings that have been kind of the thorn in your side, the scourge of your existence, whatever, for some time, and you have the legitimate right to do so. I mean, that's pretty amazing.
It's powerful.
Also, we've used patents defensively, where someone else has shut us down, based upon a patent that kind of somewhat looked like it. And we're able to show our patent, which is for what we're doing, and get the listing reinstated. Now, remember, what I said before, you having the patent doesn't mean you're not infringing, but Amazon's not sophisticated enough to know that. They don't really know how to interpret patents. So, I mean, that tactic actually works. It also showed, though, that the fact that we had the design patent that predated theirs, that our design existed before their patent, which means, like, if the patent office was seeing something patentable about theirs, it couldn't have been anything about ours, because ours predated theirs. So it's like, either we're not infringing, or that patent is invalid, because then ours should have been used to block them from getting theirs. So,
Absolutely.
There's this, it could be a tangled web, but it pays to be holding something, for sure.
Yeah.
And I could also tell you, like I mentioned before, this is lots of scenarios where people have licensed their product to other manufacturers and made more money through licensing revenue than they ever made selling products. And then I would say the last scenario, and probably the most important, is when you go to sell your business, then having IP, having the patents, having the trademarks on the brands that you use, will be a multiplier of the value.
Yeah.
I mean, people are acquiring e-commerce business, Amazon businesses left and right. They're looking for someone who has gained success with certain listings, got it to a certain level, and it's steady. And they've been valuing these businesses pretty well. But if you have the IP, if it's more than just the business that you've built up, the reviews that you've obtained and the following that you've created, if it's about the fact that you own the patent and no one else can make the product, then that becomes a multiplier of the value of the business.
What's the estimate, you think, multiplier-wise, that, compared to if you don't have the trademark or the patent, within your company to protect your brand, to protect, your big idea, to protect your product, what do you feel like is like a multiplier difference when it comes to the value of your e-commerce business?
It depends on the strength of the patent, whether it really blocks people from doing anything like it, or whether it kind of prevents them from competing on certain features, let's say.
Okay.
But it could be a multiplier of several times. I mean, because really what you're selling is the upside. So imagine if you think about like a pie chart, and if you think about, for a certain product, maybe you have 5 or 10% of the market share. Then basically when you don't have IP, you're selling the 5 or 10% market share that you've obtained. When you do have IP, you're selling the whole rest of the pie chart, because that's the upside. If a person acquiring your business and aggregating it with other similar businesses, generally they think that they're smarter than you. Like, they think that they probably can do more with it than you have, and that's why they're buying it. And so what they're buying is that whole upside. They're like, well, they got 5 to 10% market share, but with that patent, they basically own the market. So what they're buying based upon their ability to capture the whole rest of the market share by being strategic, through tactics.
Yep, totally. Nice.
Yeah.
Yeah. Well, yeah, thank you for explaining that. I really appreciate that. This has been a really valuable episode because, e-commerce business owners that are watching or listening to this, I mean, this is just tremendous because it does a lot of different things for you. One, it protects the investment of time and energy and money that you put into your e-commerce business. It also is a competitive advantage. It's also, something that increases the value of your company by taking these steps. So this is a very powerful episode, and I'm very grateful, Rich, that you've come on, that you've shared, this wisdom and this knowledge, with the audience today.
Yeah, I appreciate you having me.
Yeah. Well, I want to be respectful of your time, so we're going to move into kind of like the last bonus round. This is something we do for fun just to end the episode. Let me tell you about this.
The bonus round.
Everybody does that. So,
okay.
But so this bonus round is pretty simple. Basically, I'm going to ask you a few questions, and you have to answer each question with only one word. Okay? Okay, so what caused your biggest e-com success, especially considering with what you do to date?
What caused my biggest e-com success?
Yeah, with one of your clients, for example.
One word. God, it's hard. I would say my biggest success in e-com, I'm just going to say Simonson.
Simonson. Okay. All right. Cool. And then, what advice do you have for other e-com business owners?
Protect.
I like it. Nice. And then, how would you describe yourself?
Silly.
And what do you see in your future?
Death.
Wow, so morbid.
Yeah, if it's just one word, I mean, I think that's how it all ends, right?
Yeah, you gotta value the time you've got, for sure. Well, Rich, thank you so much for being on the show. I really appreciate it, man. And this is really powerful, and I want to really give the audience information from you on how they can reach out to you, how they can hire you, how they can, or ask you questions even if they're not quite ready for that. Maybe they're exploring trade marketing or using a patent, because you're one of the experts in the e-com field, and people need to know you, they need to reach out to you. And so how can people do that?
Great, thank you. Yeah, so if you want to learn more about the process, first of all, you go to my website, goldsteinpatentlaw.com. And I've got great resources there, great videos for learning about the patent process. Also, if you want to find out if we can help you, if it's a match to work with us, then you can contact my team either through the website, or you could email us at welcome@goldsteinpc.com. And then check out my podcast, Innovations and Breakthroughs, where I talk with people who have had success in launching products. I've had some really great guests on my show. And
I know, I've seen that, yeah.
And I think that's a great place. You can find us on social media, also Goldstein Patent Law on Instagram. And I think that's about it.
Great. Well, hey, I appreciate it. With your Breakthroughs and Innovations podcast, if you could give the audience maybe some examples of some of the people that have been on your show and what type of success that they've had, just so this way they can just see how much value is on your show. I know, I just don't want to answer it. I want you to tell them.
Got it. So I was fortunate enough to interview Rick Cesari, who has he's the direct marketing genius behind the George Foreman Grill and OxyClean and so many of those major brands. I've had Thomas Shipley, who was a major e-commerce entrepreneur behind Atlantic Coast Brands. Steve Simonson, that was the Simonson I mentioned before.
Nice.
Great guy. Guy will give you the shirt off his back. Has helped me tremendously, but also he has sold about $1 billion worth of products in e-com.
No joke.
And Kevin King,
guy who's
educated countless people through Freedom Ticket Program.
Yep. Amazon expert.
And just Roland Frazier,
legend,
genius marketer, genius at scaling businesses. Ryan Dice, also genius marketer. So many great people.
Yeah, no, that's awesome. Yeah, I mean, you said enough. Guys, you got to definitely go check out his podcast, Breakthroughs and Innovations. I'm assuming you're on probably every podcast
Innovations
channel.
and Breakthroughs.
Oh, Innovations and Breakthroughs. Sorry, Innovations and Breakthroughs.
Right.
But all those guests, I know those guests because I've been in this world for 7+ years. And guys, if you don't know some of those names, well, let me just tell you that those are like premium names in the entrepreneur and e-commerce community that really have a lot of value that they can share with you. And I'm sure that Rich does a tremendous job on his podcast, Innovations and Breakthroughs. And you definitely want to check it out on all major podcast channels. You also need to go to GoldsteinPatentLaw.com to reach out to Rich, maybe subscribe to his newsletter. This way you can learn more from him and you can reach out to him and ask questions as you start to develop or build and scale your e-commerce business. And obviously, if you need one-on-one help and assistance, Rich is great, and I'm sure he's got a tremendous staff that he's picked to represent him and his brand. So if you need help, you could always reach out to Rich as well. Rich, thank you so much for being on the Ecom Performance Marketing Show today. I truly appreciate it.
My pleasure. Thanks so much for having me, Josh.
Thank you for tuning into the e-commerce performance marketing show. If you enjoyed this episode, be sure to subscribe, like, and comment with a timestamp of your favorite part and share it with a friend. Until our next episode, here's to you and the success of your e-commerce business.